Good morning and welcome to the RHA head office in Peterborough. Today I'm joined by Stephen Myra from Backhouse Jones and we're going to take you through the story of the truck cartel so far. So, Stephen.
Morning.
Morning. How are you today?
I'm very well, thank you. Long drive, but very well.
The truck cartel. Start from the very, very beginning.
So the RHA brought the action because between 1997 and 2011, the major European truck manufacturers were found by the European Commission to have participated in anti-competitive activity. Without going into too many details, in a nutshell, they had aligned gross and sometimes list prices of vehicles, and they had delayed European technology and the implementation of Euro standards throughout that period. The cartel was found to have ended in 2011, but the RHA, there's a run-off period, which we say, and the Competition Appeal Tribunal has effectively granted a run-off period to 2015.
And so I think it's worthy of mention that in 2015, the manufacturers were found guilty by the EU and fined €3.2 billion.
Yes, that's correct. The manufacturers settled with Scania actually challenging that decision, which was and still is the largest fine ever issued by the Commission. Scania challenged it, but ultimately that was upheld by the European Court of Justice last year, and Scania were fined $880 million for their participation as well.
Okay. So then the RHA in 2017/2018 decided to seek compensation. And I think it's an important point that on behalf of the industry and its members, we are not trying the truck manufacturers. Their guilt has already been proven. This is about getting compensation that we believe, as the industry, the hauliers should have.
Yes, that's correct. So the decision establishes guilt, for want of a better word, and the whole purpose of the RHA action is to enable those who have been impacted by the decision or by the cartel activities effectively to be reimbursed for what they ought to have paid had the cartel not existed.
And in terms of process that we've been through, because it's fair to say that this case has been going for 7-8 years now, has been precedent setting, has been groundbreaking, and has been taken through a new tribunal process that was relatively new in the UK. Would you like to talk about the Competitions Appeal Tribunal?
Yes, certainly. So the Consumer Rights Act in 2015 brought about the ability through the Competition Appeal Tribunal, which is a specialist court that deals with anti-competitive practice, really, to bring what's called a collective action. In the US, they're known as class actions, but in the UK, they're known as a collective action. The RHA's claim was only the third ever claim brought under that regime. The first one didn't really get anywhere. The second claim was the Walter Merrick's claim, which is still ongoing, and then it was the RHA action. As you have identified, it's been groundbreaking on many fronts, and it's been to the Court of Appeal twice and the Supreme Court twice, and it's had a wider impact across the globe, really.
So I think it's fair to say as well that the truck manufacturers have been challenging at every turn the action that we are bringing, even though they have been found guilty of the cartel activity. So winding backwards slightly, we have got 18,000 members of the industry that have signed up to this process.
The RHA launched its campaign, I think from memory, the end of November 2017. This was brought about by members raising their concerns about the truck cartel, and the RHA then went and sought legal advice about the best possible solution. And given the nature of these claims and the fact that they are complex and they are expensive, the RHA decided to take action on behalf of the industry. So it's not just RHA members, it's anyone who bought or leased a truck during the cartel period or the run-off period thereafter.
And I think an interesting stat, because I'm a man of numbers, is that 1 in 4 claimants are RHA members, 3 in 4 are not. So it shows the breadth of the industry that we're actually covering, when we look to seek the compensation that the industry is due for.
Yes, exactly. I think this has had a really wide-reaching impact, and the It's been one of the key points that it's not just something that the RHA is doing for its membership. It is doing it for its membership, but it's doing it for the entire industry.
And as you say, it's groundbreaking. So there's been some new terms and phrases that we as an industry and individuals have learned as we've gone through this. So opt-in, what's an opt-in process and why are we following that?
So again, when I mentioned the Consumer Rights Act before, the system that was set up allowed for two types of collective actions to be brought, an opt-in and an opt-out. An opt-in action requires some positive action by people who are affected by the cartel behaviour. So the proposed class, in this case, they would need to positively confirm that they wish to be part of the claim. An opt-out, which generally or certainly historically was thought to be more consumer based. So, for example, there was a case whereby somebody was arguably overcharged £10 on a football shirt, and the sense was from that case that people wouldn't actually take positive action because it wasn't worth enough individually for people to actually concern themselves with it. So there was an opt-out process. The RHA is the first and currently the only bona fide opt-in claim that has been brought under the regime. And as you said before, it's got 18,000 businesses who have signed up and registered.
So the 18,000, it's fair to say, is a significant proportion of the industry. We believe over 60% has joined this actual claim, which shows strength of feeling, probably, within the industry for the fact that a key supplier behaved in a cartelistic, is that the right word? Cartelistic way.
Yes, I completely agree with that. I mean, certainly my memory 7 years ago, and I'm sure you remember it as well, is there was a lot of people that were upset, and you remember during that period, we had matters such as the credit crunch crisis 2008, and a lot of people went out of business throughout that period. And whilst it's not necessary for us to say, people will have felt aggrieved that they paid too much for their trucks during that period and that their businesses suffered.
So bring us up to speed now. We spent 4 or 5 years battling in court, High Court, Supreme Court, Appeal Court, every court. We got 18,000 people signed up to it, positively signed up or registered interest at that point, and they wished us to act on their behalf.
Yeah.
And then at the beginning of August, we were granted the Collective Proceeding Order, or the CPO. Mm-hmm. What's that?
So the CPO is, in effect, the legal instrument that appoints the RHA as the class representative. So what that means is that the RHA is authorised to bring the claim. So any claim that fits within the definition can opt into the RHA's claim, and the RHA will effectively conduct the litigation on behalf of the claimants, which is extremely advantageous to claimants or most operators, primarily because anyone that's ever been involved in litigation knows A, it's costly, and B, it's extremely draining in terms of your own time. So the RHA is taking this action, enabling businesses to focus on what they do, which is effectively carry goods or whatever their day-to-day business is. I'm conscious that own account operators can also sign up. They can focus on what they do and allow the Road Haulage Association to bring the legal case.
So in terms of, if I was a road haulage operator, what would be the benefits of joining this claim? Why shouldn't I look to seek compensation myself?
First and foremost, there's economies of scale. I won't necessarily use the safety in numbers, but there's a big herd here that we're all affected. The nature of this claim and the powers that the tribunal have to wield what lawyers call a broad axe means that the tribunal is able to look at this holistically and see the impact it had on the market, and then make a decision as to what the overcharge looked like. We know, for example, that in the Royal Mail case, Royal Mail, for anyone that doesn't know, went to court on their own. They're obviously an enormous business, with something of an equality of arms with DAF and other truck manufacturers, and they were found that DAF overcharged them by 5% on each truck that they bought. That was upheld by the Court of Appeal. And so we now have effectively a baseline that says, in circumstances where even where expert evidence was criticised by the court, that there was an overcharge of 5%. The advantage of being part of the RHA's action is the RHA has its own economist. That own economist will have access to a wealth of data and will be able to best position the group of claimants to identify what their damages actually look like.
So it's fair to say that the economies of scale is that there's more people that's in the claim, the stronger the bargaining position.
Absolutely, yes.
And therefore, the more detail available to negotiate a potential settlement position, which we'll come back to.
Yeah.
Or, going back to the CPO, we're the only organisation in the UK that can go to court with three judges judging the level of compensation that should be awarded against the truck manufacturers.
That's correct, yes. So I think because of the passage of time as well, anyone who wants to bring an individual action may have issues with limitation now. It's not for me to say whether or not...
They've timed out.
Yeah, they've timed out, yes. So it's not for me to say whether or not that would necessarily be the case, but I certainly think there are real challenges because you tend to have 6 years from the date of any breach to bring an action, and we're in 2024, not 2022.
And in terms of costs of bringing such a case, I mean, obviously it's been a long journey, and the legal profession is not cheap, and nor is the skill that you acquire from the economy, so it's a very, very expensive process.
Yes.
And the way that the RHA constructed the claim was to ensure that the maximum economies of scale in terms of benefit goes back to the claimants.
Yes, that's absolutely right. So one of the big advantages of the RHA's claim is because very early doors, there were a lot of people who signed up to join the action. The RHA was able to secure a really competitive funding. So litigation funding is a relatively new concept in the UK, as we well know because we've been up to the Supreme Court with it. But because the RHA had big numbers, then litigation funders were keen to fund the RHA's case, and what that means is the litigation funders pay for all the ancillary parts. If the case is successful, they get the return of their money plus a multiple of that. If the case is unsuccessful, they lose their money.
Okay, so to summarise before we move on to the what happens next part, which is fundamental to today. So we, as a trade association, have brought an action to seek compensation for any vehicle that was bought new or used.
Correct.
Between 1997 and 2011, with a run-on for both of those truck types. And that's anything above 6 tonne.
That's right. So I think it's probably worth just emphasising here that what the RHA's done following a Court of Appeal decision last year is effectively split itself in two. So that you've got one group that's dealing with the new trucks and you've got one group that's dealing with the used trucks, and that's called RHA Used Trucks Limited. It's a separately constituted board, separate terms of reference. It's been analysed by the Competition Appeal Tribunal, who was satisfied that the appropriate barriers had been put in place to ensure that both parties' information was protected. The reason why the RHA has separated itself is because there is likely to be a discussion or a counter position on pass-on of overcharge. So the first hurdle is to establish an overcharge, that i.e. every operator has paid too much for their trucks. And then once overcharge has been established, the next argument is likely to be that people who bought new trucks will want to say that they retained all of the overcharge, where people who bought used trucks will want to say it was all passed on to them. We now have two separate economists who will effectively run through the data and establish what that true position looks like.
And again, a good example of the diligence that the RHA is going into to ensure that everybody that was affected by this illegal activity is going to get some level of compensation that they deserve.
Absolutely. I mean, the RHA's key driver throughout this entire process has been to ensure that everybody gets what they're entitled to.
Okay. And we'll do some common asked questions in a moment, once we explain the process from here on into the actual trial. So again, just to summarise, we will be looking to go to trial in the next 12 to 18 months, hopefully.
Yes, I hope so, yes, unless there's more appeals.
Unless there's more appeals or settlements are offered by the truck manufacturers, which we'll come back to in a moment. So looking forward, there's a key date, the 31st of December 2024, which is when the opt-in period closes, would you just like to briefly, and then I'll summarise operationally, would you just like to briefly explain what happens in the next 4 months and what's important and imperative that claimants do?
Yes, absolutely. So if you've signed up or registered, if you haven't already, you will receive a link which will enable you to opt in to the claim. So if you don't opt in, you cannot be part of the claim. So you've got literally till the 31st of December to take some form of action in order to make sure that you preserve your opportunity to be compensated.
How do people physically do that?
So they will be sent a link from the RHA, which they will then need to complete. That link will enable them to view all the appropriate documents, including the Rule 81 notice. And just briefly, by way of explanation, the Rule 81 notice is a document that is approved by the tribunal that explains all of the key elements of the case. So without going over too much old ground, because we've just discussed some of the points, but what type of trucks are included, what type of operators can claim, what the impact of any settlement might look like, what action needs to be taken, what happens if you don't take any action.
And we're asking the operator to complete that within 48 hours so we can process the volume, because we've currently got 18,000 operators to process in the next 4 months, 3.5 months. So it's important that when you receive the Notice 81, if you don't understand the content or have got any questions, contact us on the details that will be contained in the email.
Yep.
And complete it as soon as you can.
Yeah, it's really about, I mean, as you've just identified, 18,000 operators is a lot of people. And so as soon as people get there, we would encourage them to opt in. It's really important, and we don't want it to get lost in people's inbox, because there's no get out of jail card after this. After the 31st of December, if you've not opted in, you're not going to be able to participate in the claim.
So for clarity, at this moment in time, you have registered interest up to this point over the last 6 years in the Cartel claim. Now it's time to fill in the Notice 81. And at that point, you will have actually joined the RHA Cartel claim.
That's correct. We have hopefully designed it to be relatively user-friendly. We have to direct you to the key documents. We encourage you to read the key documents, raise any questions with Red and her team. If you're not sure about anything, but if you're happy, then you should just be able to tick a number of boxes, and you'll then receive confirmation that you've opted in and you are formally part of the claim.
Okay. And then after that, you'll receive a request for vol information, which is from the Traffic Commissioner's database, and that information is critical to allow us to validate the claim. And all you will need to do is to fill in and download information in a certain format and send it back to the email address that it arrives on.
That's correct. So you ought to get an email with a self-explanatory guidance as to how you, for want of a better word, extract your vol details once you log into your vol system, and then you effectively copy that, paste it, and send it back.
So there's two things that we're asking operators to do now. One is complete the Notice 81 within 2 days, and then provide us the vol information, ideally within a further 2 days. And then we can start to process the 18,000 hauliers that have signed up to the claim and be in a strong position from the beginning of next year to move towards a trial to get your compensation.
Yes, that's correct.
The likelihood of settlement, Stephen, what's our view on the likelihood of the truck manufacturers approaching us and offering the settlement?
First and foremost, most of these claims settle. We're aware that there's been settlements across Europe in the truck cartel. We are aware that statistically the vast majority of competition infringement claims settle. And as you were sat there, we're also aware that DAF stood up in court at the last CPO hearing and said that they wished to settle the claim. And so we're confident that the claim will settle, but obviously there's no guarantees. And part of our role as legal advisors and your role as the RHA is to make sure that we achieve a good settlement for operators.
So in terms of settlement, if an operator decided he wanted to, for whatever reason, go and settle directly with DAF, they would have to firstly inform us that that's what they wish to do, because they've already registered interest.
That's correct, yes, so the CPO requires that.
Irrespective of completing Notice 81, they have to inform us before that point that they no longer wish to be part of our claim.
That's right. So if for example, DAF offered £100 a truck, which to my knowledge they've not done yet, but if they did, then anyone that receives that offer who has already signed up to our claim needs to let us know.
And by leaving the claim as well, any other make or model of truck they had bought other than DAF would not be eligible in the claim going forward. So if I was an operator and had bought DAF, Mercedes, MAN, Scania, and I left the claim, I'd be leaving with all of those truck manufacturers and just having a relationship with DAF. I wouldn't be able to be represented by the RHA for the other truck manufacturers.
That's correct. If you don't opt in by the 31st of December, you can't be part of the claim.
What about non-mainline manufacturers such as Ford? Where do they sit in this claim?
So there's a legal principle known as umbrella purchases, and the legal rationale is that if you've bought a non-cartelized product, that you are still likely to have overpaid because of the impact that the cartel had on the market as a whole. So we know that the five major manufacturers account for an enormous percent of the market, and therefore anyone who wasn't part of that cartel will have priced based on what their competitors were doing. And so if their competitors were overinflating their prices, then they'll have overinflated their prices.
Okay. So in terms of just going back to DAF and settlement, and standing up in court and proclaiming that after 7 years, when a lot of businesses had gone bust, when people had left the industry, and when they'd fought this claim so hard, driving in lots of cost, needless cost from a settlement perspective, that they wish to settle with the industry and would like to do so on a direct nature with each claimant.
Yep.
They then, from our perspective, issued and wrote to everybody with information that was misleading from a funding perspective, and we strongly push back on the implication that that information gives to the industry. And we strongly urge anybody who's signed up, thinking about speaking with DAF directly, to speak to us first. So we can, you're obliged to speak to us first, so we can give you a counter and a balance and explain the process to you going forward and enable you to make your decision by the 31st of December.
Absolutely.
Is that a fair comment?
That is, 100% fair comment, yes.
Welcome back. I'm now going to take the next 4 or 5 minutes just to ask Stephen some frequently asked questions. As part of the process to sign up by the 31st of December, we are running a series of webinars, and these webinars have provided a commonality to the questions that have popped up. So Stephen, in no particular order, if I may. If I'm not sure whether I qualify to actually sign up to the cartel, what should I do?
Contact the RHA and then have a discussion with one of the RHA members of staff.
And this is a question that we've covered already, I think, this morning. But I've heard that DAF are prepared to settle individually with claimants. Why should I stay with the RHA claim?
Economies of scale would be one obvious answer. So the bigger the group, the better your collective bargaining. That would be my primary view as to why you should stay with the RHA. The secondary view is fundamentally you're only in position to receive an offer from DAF in the here and now because of what the RHA have done, so bringing the action in the first place, and this was something that the tribunal recognised.
If over this long period of time, as a number of businesses will have done, have ceased trading, can I still claim?
It depends as to the status of your business, as in the legal status, and when it ceased trading. So if you ceased trading and you're a limited company in the last 6 years, then you can reinstate that company. You'll have to go through a process, an application to the court. But again, if you're in that position, call the RHA up. They'll put you in touch with us and we'll be able to make that application for you. If you were a sole trader or a partnership and historically you ceased trading, you'll be able to claim. If, however, you're a limited company that ceased trading more than 6 years ago, you won't be able to, unfortunately, reinstate that company.
And if I don't have any documentation for any of the trucks that I have bought, brand new or second hand, can I still be part of this claim?
Yes, absolutely. Providing you've got some details, i.e. who you were and when you traded, then the RHA will be able to take such steps in order to be able to find the information. So we've various sources of where you may have bought the trucks.
And just linked to that, the vol information, which is a crucial second part of the information required between now and the 1st of December. That only goes back to 2003 in England. So what's the plan from the Cartel team to find the information prior to that?
So we have already spoken with the Traffic Area Office back in 2017 and asked them to retain all records so that in the event there are missing records from operators, we'll be able to then go to those archives and hopefully find them.
Can the estate of somebody join the claim? So someone that is deceased and then their estate actually become part of the claim?
Yes, but only after 2018, if the person died after 2018.
And the most frequently asked question, the final question, is how long until the case will be concluded?
It's a difficult question. We're aiming to get this concluded as quickly as possible. Everyone at the RHA and everyone, the legal team and the economist is working as hard as possible to get this matter concluded. We're conscious that the cartel started in 1997. It's in excess of quarter of a century that someone may have overpaid for their truck. Equally, this case is precedent setting. It's one of the biggest cases of its kind, one of the biggest cases in Europe, and we are fighting 5 well-armed truck manufacturers, and I mean armed in terms of legally. They've employed big city firms who are defending this very hard.
And from an RHA perspective, does the RHA profit from this action in any shape or form?
No. Look, there's costs that obviously need covering. For if you're going to print off 100,000 letters to write to people, then the RHA is now to pocket, but it's not profiting.
And in terms of the reason why the RHA is bringing this action, which is a question to myself, I think, as the MD for the organisation, is what a trade association should do to support, represent, and maintain the reputation of its industry.
Yeah, I 100% agree with that. The reality is that most businesses that are part of your claim wouldn't have the financial resource to actually bring an action of this nature. They're very complicated, they're very expensive, and they're very time consuming. And the RHA has stepped in, has allocated resource to assist with the running in this claim. And as well, it can be very demanding of time.
Well, Stephen, thanks very much for your time this morning.
Very welcome. Good to see you.